A very good evening and a warm welcome to the Asian International Arbitration Center, or more commonly known as the AIAC. My name is Ragini, and I'll be your Master of Ceremony for today's AIAC Evening Talk series. On behalf of the AIAC, we are truly pleased and honored to be able to welcome and host all of you today. Today's session is entitled Navigating Disputes in Times of Sanctions. And this session will be moderated by our very own Ms. Ng Chu-yin, the AIAC's Head of Legal. Chu-yin worked as a quantity surveyor for about 10 years in Malaysia, New Zealand, and Australia. She then worked in a local claims consultant firm for about 4 years while studying law. Then she practiced as an advocate and solicitor in a law firm which specializes in construction disputes. Chu-yin is now the head of legal at the AIAC. Without further ado, I will now hand over the floor to Chu-yin to introduce the esteemed panel of speakers. Over to you, Chu-yin.
Thank you, Ragini. Good afternoon, everyone. It is our pleasure to have all of you today. We have many new faces here today, and some of them are old faces as well. Welcome, everyone. And I know this is today is not a good weather, and everyone still turn up. And I think everyone deserves a clap, like a round of applause to yourself. And I promise that today will not be a normal evening because we have 3 esteemed panelists today. And what we hope to discuss today is about the impact of sanctions on the resolution of commercial and investment disputes. I would like to introduce each of these speakers today. I'll start from Anis, who is sitting beside me. Anis is a partner at Cecil Abraham and Partners. He specializes in construction and infrastructure, as well as arbitration and adjudication. He has extensive experience in both advisory and advocacy aspects in this area and has been involved in both international and domestic arbitrations held under the SIAC, the AIAC, ICC, and also LMAA rules. Anis sits both as the arbitrator and also adjudicator on various construction disputes, being a panel member of various institutes, including the AIAC. And apart from construction issues, Anis is also active litigator focusing on commercial disputes and has appeared as counsel before the High Court of Malaya, the Court of Appeal of Malaysia, and also the Federal Court. And I now move on to Dimitri. Dimitri is a partner with Dispute Resolution Practice and managing partner of RGD International Central Asia. Dimitri focuses on the resolution of disputes involving the governments, primarily investment disputes and investment arbitration. Dimitri possesses vast experience in representing clients in international arbitration proceedings under UNCITRAL, SCC, LCIA, ICC, Swiss Chambers, SIAC, WIPO, ICAC rules, and in the Russian state courts, including the bankruptcy proceedings. Dimitri is also included in the list of arbitrators of the Arbitration Center at the Russian Union of Industrialists and Entrepreneurs, which is known as RUIE. Dimitri is also a member of the nomination committee of the Commission on International Arbitration, ICC Russia. He is also a member of the CIR, and he is also included into the Shanghai International Arbitration Center's panel of arbitrators. Next, we have Rinat. Rinat is a US qualified attorney admitted in the New York Bar. He holds civil and common law degrees. In his current role as a legal consultant at a New York-based law firm, Rinat represents domestic and international entities on a variety of general corporate matters and cross-border transactions, as well as assisting clients in navigating complex commercial disputes. And prior returning to legal consulting, Rinat has gained experience by working and training in leading arbitral institutions in Malaysia, South Korea, Russia, international organization UNCITRAL, and also law firms. Through Rinat's professional and educational experience, he has developed expertise in trade law, aviation law, arbitration, cross-border dispute resolution, and he has also published several papers in international and local journals on issues relating to cross-border resolution. Please give our round of applause to our esteemed panelists today. I'll just explain a bit on how we are going to structure today's talk. Anis is going to start from the Malaysian perspective, and Dimitri will cover the challenges with sanctioned parties in the international arbitration, and Rinat will touch on navigating the US sanction regime in international arbitration practitioner. So Anis, the floor is yours.
Thank you, Julian. Well, firstly, I have one question whether sanctions are really a myth insofar as Malaysia is concerned. But having said that, before we look at the dispute aspect, let's actually try to figure out what sanctions are, which countries are actually out there recognizing it and in fact enforcing it. Sanctions, generally speaking, are politically motivated, restricting economic, trade, financial, and investment measures that target various states, entities, or individuals, limiting their economic interest and/or rights, or in other words, crippling them. This in turn results in global repercussions that affect, amongst others, trade and investments, resulting in resolution of disputes, which unfortunately are also impacted by sanctions, the practical side of which we'll be speaking about today. Now, insofar as Malaysia is concerned, Malaysia does not recognize sanctions on any country unless it is a resolution adopted by the United Nations General Assembly. In the perfect, or rather, a more certain world, it'd be easy to follow the due process by which, if there is a sanction, it has to go through the UN. And if the resolution is passed by the UN, then as a member of the UN, you have to respect and abide by it. Easier said than done. But then again, some superpowers like to impose unilateral sanctions. So insofar as Malaysia is concerned, just about 3 to 4 years ago, bank accounts belonging to Iranian individuals and companies in Malaysia were suddenly ordered to be closed, which is due to the US sanctions. Bear in mind, there were 100,000 Iranians living in Malaysia with more than 20,000 students, import and export alone in total between Malaysia and Iran, reaching almost $500 million per year. And what kind of an impact that would have caused. Now, 2 major banks in Malaysia did that. They closed their accounts as they were threatened that its branches abroad would be closed if they failed to do so. This is exacerbated by the fact that most, if not all, commercial banks have some connections to the US banking system and may be thus exposed to prosecution by the US authorities, even if they are not US banks. So for example, BNP Paribas in 2015 were required to pay 8.83 billion due to financial dealings with Sudan, Cuba, and Iran. And in 2019, Standard Chartered Bank agreed to pay 1.1 billion USD to US and British authorities for sanction breaches relating to dealing with Iranian countries. Anyway, the manner in which the sanction regime works in Malaysia is by the implementation of the same through domestic legislation to give effect to various UN sanctions. Generally, sanctions imposed by Malaysia through relevant legislation and ministerial orders take various forms, such as embargoes which prohibit export, transshipment or transit of strategic items or unlisted strategic items, freezing, seizure, forfeiture of funds, and other financial assets. And of course, the main legislation for us is the Strategic Trade Act 2010, and more in terms of not really relating to disputes, since terrorists don't go to arbitration. It's the Anti-Money Laundering Act that's enforced here. That's insofar as Malaysia is concerned.
Thank you, Anis. Dimitri, would you like to touch on the key challenges on international sanction arbitration on sanctioned parties?
Sure.
I think you need to use the mic because it's online. Yeah.
No, that's fine.
Yeah, you want to go to podium?
No, I can. No, that's totally fine. All right. All right. So my name is Dmitry Kaisin, and thank you, Julian, for this introduction. I'm from a Russian law firm, Rybalkin, Gartsunyan, Dyakin and Partners. We do a lot of international arbitration for our Russian clients and clients from the former Soviet republics. ambit are sanctioned, introduced after February 2022 and even earlier. We have faced, the country faced and the businesses faced a lot of impediments in international arbitration. We have been dealing with different issues related to sanctions for a long time. And I want to share with you our experience on that. So first of all, I would like to start my presentation with an illustrative citation by a prominent Australian arbitration professor, Doug Jones. He delivered a speech at the Global Arbitration Live Construction event held on 31st of March 2022, a month after the Russia-Ukraine conflict sparked and sanctions started being implemented. So so you see it on the screen. Law firms are being prevented by international sanctions from representing sanctioned Russian parties, which raises issues about how to ensure that the rule of law prevails in disputes involving such Russian parties. Whether caused by voluntary withdrawals or by sanctions regimes, the unavailability of lawyers affecting the administration of justice in a range of matters. The rule of law needs to be taken seriously in the context of resolutions of disputes, and all participants must be given adequate representation for any justice system to work fairly. I think it's a very important citation, and I am pleased that the prominent arbitrator even just in January 2023 chaired a panel in our construction dispute in Singapore recently. So let me tell you what kind of troubles Russian parties and Russian lawyers usually face during arbitration proceedings. So first is payment of arbitration fees. In a prevailing number of cases, you are stuck just at the beginning. You simply cannot pay a filing fee, and it's not usually a problem of the institution itself, but of its bank, who rejects any payments from Russia. The situation has been changing, and for instance, the London Commercial Arbitration Center obtained a license to receive the payments, and we do not experience any problems there since recently. In one our ICC case, we managed to persuade ICC and the tribunal to continue the proceedings, notwithstanding the fact that sanction claimant didn't pay the advance and cost. We even conducted an evidentiary hearing in Istanbul in September 2022. But ever since, the tribunal hasn't even started drafting the award. We understand that the tribunal follows the instructions of the ICC court, and the ICC court is awaiting the receipt of advances and costs, which we cannot pay as long as the bank rejects payment and as long as ICC is very slow in receiving a specific OFAC license. OFAC is a special body of our US executives who is in charge of sanctions. So we were recently informed that the ICC had obtained licenses in respect of US president orders of 2022, but not in respect of the earlier one of 2018, which has relevance to our claimant in that matter. The situation has been also difficult with the Stockholm Chamber of Commerce. In one of our cases, commenced before the Ukrainian conflict, we managed to persuade the court to accept a Swiss bank guarantee to secure the costs, since their bank rejected an advance payment on behalf of a US sanctioned company. The other problem we frequently face is engagement of a local counsel and experts in different fields, law, damages. So for some time, it has been a problem to engage them, especially in certain EU countries, as well as in the UK and the US, and both to administrative and to due to administrative and ethical issues. But the situation has been changing since then. So, for instance, now the British regulator, it's OFCI, granted general license, which allows law firms and barristers to receive £500,000 for advice given after the designation. In EU, transactions with Russian state-owned entities are exempted from EU sanctions regime, where they are strictly necessary to ensure access to arbitral proceedings. In the United States, certain legal services for sanctioned companies are generally authorized. For instance, representation before domestic courts, while other require specific license. In our recent case, OFAC clarified that legal advice on requirements of US law for designated entities in international arbitration and associated payments are allowed by a general license. We were stuck in that arbitration because we couldn't receive advice on how US sanction works, because that was one of the issues in that commercial dispute. And our expert, he applied for that specific license, or he either asked for clarification whether his participation and receipt of funds from a sanctioned company is covered by a general license. So we get he finally got that answer. Actually, it took half a year to get a response from the OFAC saying that you can proceed and it's covered by a general license. Appointment of arbitrators is another challenge. Although a number of arbitrators willing to accept the appointments has decreased since 2022, there is still a significant pool of highly qualified arbitrators who continue accepting the appointments from sanctioned companies. At the same time, international law firms who frequently nominate arbitration practitioners and academics, primarily from the Western Europe and the United States, experience troubles and often request extensions to nominate an arbitrator. Arbitral institutions, for example, our Singapore Arbitration Center just recently granted, he was mindful, I think, the center, it was mindful of such concerns and grant extensions. And in our experience, many centers grant such extensions if such reasoning is given by the other party. So even though we have received a sanctioned party has received an arbitral award in its favor, the other problem is to collect on that arbitral award. You don't just need a piece of paper, right? So sanctions regulations usually contain no claims, no liability provisions, which restrict sanctions-related claims. The arbitral award thus cannot be enforced in the European Union if it is satisfied the claim made by the EU sanctioned entity and arises from European Union sanctions. Moreover, Article 11 of the regulations on the screen is often seen as preventing arbitral tribunals seated in the European Union or applying the European law even to issue awards in favor of European Union sanctioned entities. However, in certain cases, the awards may still be enforced, for instance, in neutral jurisdictions or in case a license is issued. But I'm not aware that even once such a license was issued so far. But what I can say, it's a very good example. Just 2 weeks ago, the United Kingdom Court of Appeal confirmed in the Mintz case that UK sanctions regime does not prevent courts of the UK from entering judgment in favor of the sanctioned person in civil litigation, and that the British regulator or OFCI can license payment of cost orders in favor of or against a sanctioned person. So given such challenges, what we have been thinking as a firm, what we should do. So most of arbitration practitioners in Russia observe that Asian arbitration institutions, in particular HKIC, SIAC, and GIAC, where the above problems are either wiped out or easily resolved, are becoming more and more popular among the Russian parties. We also see some interest to other jurisdictions in the region, of course, including Malaysia, but quite rarely at the time. According to the Asian Arbitration Center Annual Report 2021, it has registered only one matter with a Russian party. Further, I would like to mention that there was an example of successful enforcement of Russian arbitral award in Malaysia, and I think it's generally a good sign for Russian parties. As a countermeasure in Russia, Russian legislator, Russian parliament enacted special legislation, so-called Lugovoy law. Generally speaking, that legislation allows sanctioned companies to bring claims to Russian courts, irrespective of arbitration agreement. And this is possible when a Russian court finds, according to a very, very low threshold, that sanctions may affect the right of a party to present its case. So, as a countermeasure, in such cases, foreign parties apply to foreign courts in common law jurisdictions for anti-suit injunctions, and they're usually successful. And we had that example recently in Hong Kong. Thank you.
Thank you, Dimitri. Before moving on to Rinat, Dimitri, you mentioned about the Hong Kong case just now. Would you like to elaborate a bit more on that one? Yeah.
So I would say it's a kind of saga. So it's a case because this case is ongoing in at least 4 jurisdictions right now. Russian company Russkим Allianz and their German entity Linde, they entered into EPC contract in 2021. And ambit to sanctions, Linde discontinued performing its obligations under the EPC contract. So what did the Russian company do? At the end of last year, it received it received a freezing order from the Russian court in support of future arbitration, in aid of future arbitration. It said that it was going to commence proceedings before the HKIC, according to the arbitration clause in the EPC contract. But suddenly, the Russian company changed its mind, and it applied to the same commercial code of St. Petersburg and Leningrad Oblast, saying that I'm not going to file any claims in Hong Kong in arbitration. I just want to use that Lugaway law I just told you that, and the court ruled that irrespective of the arbitration agreement, it had jurisdiction to try that case. So what Linda did, Linda in turn actually commenced arbitration in HKC, and it applied to the local court of Hong Kong, who issued anti-suit injunctions against the Russian company. The obligations of Linde were also secured by some very big international banks, and the arbitration clause in those guarantees, it was ICC with seat in Paris, and the banks, they applied to English courts. Yeah, and I need to mention that the governing law of guarantees was English. So they applied to English courts instead of French courts. Probably you know that French courts do not issue anti-suit injunctions like many common law countries do. So they relied on English law as a governing law, and that was the link to the UK judiciary to grant freezing injunctions, to grant anti-suit injunctions against the Russian company. A Russian company did the same as it did with Linder. It applied to Russian courts to collect on the guarantees. And instead of commencing ICC arbitration, it also used Lugaway law, that counter-sanctioned legislation. So the English judges were not uniform in applying anti-suit injunctions. So in one case, at least as far as I remember, English judge refused to grant anti-suit injunction, saying that it has no jurisdiction to grant them. But in other cases, and there was a recent Court of Appeal judgment, maybe 2 weeks ago, saying, no, we have jurisdiction and we may issue anti-suit injunction. So that is saga is going on in Russia. There is still no final judgment. I really do not like the reasoning about the HKC, why the Russian court found that HKC is not a fair place to try dispute, and why Hong Kong is not good enough in the eyes of the Russian court. But I would like to stress that it's only the judgment of the first instance court, and it is subject to further appeal once the final decision of the Russian court is delivered. Then I think Linda will likely challenge that conclusion of the first court instance.
Thank you, Dimitri. All right, now we have touched on the area on key challenges by Dimitri, and also from the Malaysian perspective by Anis. We are now moving on to the US sanctions regime, where Rinat is going to talk more on the US Department of Treasury's Office of Foreign Asset Control, OFAC. The floor is yours.
Thank you. So now moving to the place where it's all coming from. So first of all, it's a pleasure to be back in Malaysia. First time since 2018, when I came here to join AIAC as an intern at that time. But now, today I will be covering US sanctions regime. And to set the floor, let's set the stage with a hypothetical arbitration scenario. So picture a Russian company and an Italian company in a dispute with the arbitration taking place in Singapore and a Swiss law governing the contract. The Italian company refuses to pay the Russian company's invoices citing the US sanctions on Russia. And then a claimant, the Russian company, argues that the respondent has no business operations in the States. It has no bank accounts in the United States. And then it has no reason to invoke the US sanctions as such. The respondent contends that the US dollar account in China with a Chinese bank was determined the only payment method, and then the transfer of the US dollars to Russia will then violate the US sanctions regime. So then I would like to invite you to play as an arbitrator. So imagine two scenarios here. So you are a Malaysian arbitrator, and then would you think that US sanctions has a potential to be applicable in this scenario? So I want to see the poll of hands, if yes. Do you believe the US sanctions would apply? Okay, so it's one hand. Let's change a bit. Let's say you are a US person, so you are an arbitrator for the US person, then would you believe that you will be subject to the US legislation restrictions? As an arbitrator. So still we do have two people here that do believe that sanctions could potentially apply. I expected much more hands actually. So the answer is always yes and no, depending on which party you do represent. But then I do believe that these days, the correct answer will be yes, they do apply. And that's because the US secondary sanctions reach far beyond US borders. And that's all because of the US dollar's dominance. And my hypothetical scenario is based on a real case that the settlement between the Office of the Foreign Asset Control mentioned by Dmitry and the British Arab Commercial Bank. In that case, the British Arab Commercial Bank made a payment in US dollars to the US sanctioned party. And in that case, as the money was going through the US bank as an intermediary, the OFAC decided that they had powers to catch the bank. On a practical level, sanctions can significantly impact the arbitration process itself, including, as Dmitry mentioned, limiting the ability of counsel, arbitrators, and arbitral institutions to assist the parties. Among other challenges, many programs that were introduced by OFAC, they restrict the provision of certain legal services to listed entities and individuals. I can get a clicker. So the involvement of a US sanctioned entity as a party of the international arbitration proceedings will not necessarily preclude the arbitrator or the arbitral tribunal or US counsel to accept the appointment. However, it requires in many cases taking additional steps, and that's the obtaining a licenses. There are two types of licenses, the general license and a specific license. So the general license will automatically allow certain transactions that are typically will be prohibited under the US sanctions regime. On the contrary, the specific license will require a direct application to OFAC. So that will be the case that Dmitry mentioned as a law firm applying to receive a specific license. Interestingly, usually it will take 77 days to get a license. These days, considering the enormous amount of influx of Russia-related cases, that takes up to half year in real example, even more in a real example. I would say it's more actually, it's been 7 months in one of the cases I handled. So, but the US programs against North Korea, Iran, Venezuela, recently Russia, they will now mention that and expressly authorize the provision of arbitration related services to the sanctioned parties. And I would like to highlight here that's conduct and initiation of arbitration. It does not mention enforcement, settlement, or let's say garnishment. So then, but for many US sanctioned programs, the specific license is the key for a US person to act as a counsel or arbitrator in international arbitration, or importantly, to get paid for that work. To this end, OFAC has previously issued licenses permitting arbitrators, counsel, and all other persons participating in arbitration to engage in all transactions that are necessary and ordinary incident to it. So all of the specific licenses will need to be secured before particular engagement or transaction in question is entered into. And here, one more observation from my end is actually, it's not only obtaining the license, but then you must remember that before that arbitration concludes, the license must remain valid. One of the real cases where the arbitrator had to apply and then resubmit the application for an OFAC specific license before he could deliver a final judgment in an arbitration. And then the losing party actually invoked that, tried to invoke that as a claim that he did not have powers to render the award. He acted against the US sanctions regime, but then failed that argument. So now you might ask, should we here in Malaysia even be worried about US sanctions? And you might indeed wonder, do these concerns about US sanctions really apply to us here in Malaysia? And I see that many of you actually believe that, no, we're quite far from US. So the US will not catch us as the arbitrators here in Malaysia. But let's circle back to the hypothetical with which I started my presentation. And remember that the US secondary sanctions can reach beyond US borders and even here in Malaysia. And if the applicable US sanction program additionally imposes secondary sanctions, non-US persons, including non-US counsel, arbitrators, and arbitral institution may need to consider their exposure to US sanctioned laws, particularly where the payment is made in US dollars. So that will be very wise, even not to apply for a specific license, but to seek the confirmation from OFAC whether we do need that license in the first place. I do understand that it might take quite a long time now, but then it's much safer solution than simply proceeding with it. And then some arbitral institutions have anticipated this possible secondary sanctions exposure and have implemented practices such as using a non-US dollar currency to conduct transactions related to arbitration. So one of the examples will be the HKIC that say that they may use or avoid a certain currency to facilitate payments where sanctions affect the proceedings, where ICC's policies more explicitly mandate that no payment, including the payment of the filing fee, by any party in the matter shall be made in the US dollar currency, where any party is subject to the US sanctions. So while legal landscape in Malaysia might seem distant from the US sanctions, we are still part of a connected global legal world. And understanding the specifics is crucial in today's international arbitration field and commerce. So even from the distant shores of Malaysia, I would say that the impact of US sanctions can ripple through our legal affairs. And it's a complex but still fascinating area of law that we practice these days. And for that specific reason, just because we do not have a full understanding how sanctions could affect our parties and arbitrators and colleagues, let's say in Singapore, in Kuala Lumpur, in Moscow, or in New York. A couple of months ago, we came up with an idea to gather together practitioners and scholars and invite them to submit their experience and share their experience and submit their vision on how sanctions and international arbitrations actually interact in practice. So up to date, we have received more than 40 submissions from all over the world, but still in my capacity as one of the member and the person who actually came with that idea, I do invite all of you to participate because unfortunately, we haven't received anything from Malaysia. So Anis shared that we do not have any experience with sanctions yet, but as I shared, that I do believe that sanctions are here and they can get to Malaysia very soon, actually. So if you do have any experience, or colleagues might have experience, we do invite you cordially to take part in the project. Thank you.
Thank you, Rinat. Rinat, just now you have mentioned about insofar as the arbitration proceeding is concerned, the arbitrator has to ensure that the OFAC license have to continue to be enforced before he issue the arbitral decision. But I would like to ask this question first before I pass the Q&A session to the audience. If OFAC declines to grant a license, how and whether or not the arbitration proceeding can continue?
I will make it simple for myself. Let's imagine that an arbitral institution applied for a license, but for some reason declined to grant a specific license to the arbitral institution. To the best of my knowledge, only one arbitral institution in the whole world actually provided some guidance on what they will be doing in that specific case, and that's the LCIA in London. So as per them, if they fail to obtain a license, so that's why they could not legally administer the case, then they can reject that case and withdraw from administering the case. Practically speaking, I think what I saw the CIS part is actually doing these days, and that's quite wise, to my opinion, is to have several arbitral institution listed in arbitration clause as an option, and then once the matter arises, the claimant will determine which is the better option for them in this case. So let's say if we've seen that some of the arbitral institutions, they said we will not accept, it will not work, or we see that arbitrators in that jurisdiction, they've been rejecting the appointments, then we can, or as Mitri mentioned, it's not possible to make that payment. So then we will make a choice towards a second option or third option. So that's one of the options. So it's a bad thing if OFAC declines, but there are some ways to play around.
Thank you, Rinat. Anis, do you have other views?
Yeah, just to go back to Renat's earlier one, perhaps I should clarify. We do have some experiences where the word sanction has been exploited. It has been used as defenses in court proceedings, especially when it comes to performance bonds or even in aid of arbitration. So they would say that remitting USD would be a breach of the US sanctions. But like I said, US sanctions is not recognized in Malaysia per se. But of course, you're right in pointing out the secondary sanctions, which has more effect. And we also have cases where they will say they are just completely unable to remit the monies and so on. Luckily for us, and to the best of my knowledge, the courts in Malaysia have rejected the defense of sanction, or I've not come across a case which has been decided properly in terms of whether sanctions are recognized in Malaysia, if it's by the UN. So on that note, I think we're still going in a very fair manner. So yeah, we do have some experience.
All right, thank you, Anis. We will now open the floor. Yeah, you do have a question. Can we pass the mic? Thank you.
Yeah, hi, I'm Philip Teo. I'm one of the arbitrators of the center. Actually, my question is, actually, I've got two cases in the Admiralty Court involving sanctions. And one of them involves Venezuela sanctions. And that's the whole aspect of the Venezuela sanction is front and center in the dispute. the case is ongoing. The next stage is the experts on sanctions law will be called to the court in November, and there'll be some hot tubbing to decide. I've got several. I've got questions on the OFAC sanctions. Any payment made in USD, does it automatically go through the US system? I mean, that's my first question. I've got another.
Thank you. That's quite a technical question, but to the best of my knowledge, if the payment is made in US dollars, that it will be transmitted through the US intermediary bank. So that's why they're able to catch it and that say that we do have the power of it. So, but maybe there are some banks that somehow able to do it through a non-US intermediary bank. I would imagine a Sharia banking system where you actually do not transmit any money, but then it somehow comes to your bank account in other country. But then usually speaking, yes, so that will be going through the US intermediary bank.
So in the case which I'm arguing before the Admiralty Court, one of the parties tried to make payment in euro dollar. So that's how they were trying to, overcome the sanctions regime. The other question is also on OFAC. Basically, there's primary and there's secondary sanctions. But in the case which I am arguing before the Admiralty Court, which involves Venezuela sanctions, my client who sold Venezuela cargo said that they are not caught by the SDN designation under OFAC, and the cargo they sold is sanction-free. Do you have this concept sanction-free? Because my understanding was if the US sanctions catches Venezuela and Venezuela exports the oil, that means it's caught by the sanctions. In fact, Venezuela the US OFAC just lifted the Venezuela sanctions yesterday.
So I myself sanction-free, I hope. So, but to answer your question, I think it depends. So it's one type of the sanctions that will be the person listed in the SDN list. So that will be covering that person, so the individuals, the companies, etc. And then on the other hand, we do have transactions as a general thing. So it says you cannot have any business with that covered individuals and entities, but at the same time, certain types of transactions with the country or with the goods coming from certain jurisdiction also prohibited, to answer it quickly. So have to be careful. It's not only about that specific entity or person isn't in the SDN list, but we need to see what the substance of that transaction as a whole. Anything else?
Yeah, I'd like to.
So as I previously said, our US expert, who is a US qualified lawyer, he received clarifications from OFAC saying that general license authorizes payments in arbitral proceedings or in court proceedings in the United States. So, and payments made to that counsel, expert, or an arbitrator. So, in that sense, I don't see any impediments to receive money in United States dollars. As far as your second part of your question is concerned, it is very difficult to answer that question straight away. I may say we have like 15 people in our headquarters in Moscow who specifically deal with sanctions, with Russian-related sanctions, and there is now just a lot of people in the CIS or in many other European countries, in the United States, in Britain. Yeah, so there is a specific, I would say there is a specific field of law right now, sanction law, and you need to dig into to answer your question.
Thank you. Do we have other questions? You have a question? Yes.
Sorry, not I dedicate to your question. I was wondering because you told that it's possible in arbitration clause to state several institutions. I'm just wondering from practice, because sometimes when there is a dispute, parties of the contract trying to get away from arbitration clause. And on the one hand, it's applicable with regard to sanctions, but on the other hand, will it make the arbitration clause weaker because there are several institutions and there will be some kind of possibility to use it as to avoid or just to stop arbitration proceedings because there are several arbitration institutions and there is some manipulation to appear?
I would say that I could see potential issues with that if you would mention arbitration and litigation. So you will mention an arbitral institution in the same time, in the same clause you will mention, or the court in Singapore, let's say. So there you can say and potentially argue that you have not made your choice for arbitration. At the same time, if there are several arbitral institutions listed, so I'll take it as an option only, and perhaps argue that it's a clear agreement of the parties to refer the dispute to arbitration. And then once the claimant submits the case, then we say that's how they actually made their final decision on that specific arbitral institution. I do believe that Dmitry might have something to that.
Yeah, so we've been dealing with this a lot, and my corporate colleagues approached me several times for the last year, asking what shall we put in our contracts. My recommendation now is, as Renat said, using different arbitral institutions. It could be either alternative arbitration institutions. It could be a cascade arbitration clause. It's not only about institutional arbitration. I usually recommend to have ad hoc arbitration and to have the appointing authority, an alternative appointing authority. We usually recommend using either CIAC or HKC in that case. So there is a lot you can do, but we do not strongly recommend designating only one arbitral institution and only one arbitration rules. For sure, no.
Thank you, Dimitri and Renat. Before I pass the floor for the next question, I have a question. What factors would you take into account when enforcing an arbitral award issued in favor of sanctioned entity? Anis, would you like to answer this?
Yeah, but I think just before that, I also have a question actually, because sorry, insofar as Asia is concerned, I think Singapore and Japan have imposed sanctions against Russia. And first question is, does that affect SIAC, SIAC, as a forum? And secondly, I also understand Russia has allowed SIAC to administer cases as long as the seat is in Russia, in some form of a license, if I'm not mistaken, how it works. So has that affected Russian parties being arbitrated in SIAC?
Thank you. It's an interesting question. So now we have four cases before Singapore International Arbitration Center. At the beginning, it was pretty hard to overcome some barriers we had. But finally, all the issues were resolved by the center or by ourselves. We managed to pay the advances and costs, and we are maintained the arbitral tribunal to continue resolving our dispute. So we finally had hearings, as I said, in January for 2 weeks in Singapore. So, but in eyes of many, in eyes of some Russian practitioners and some governmental officials. SIAC and Singapore is not a forum for Russian-related disputes because Singapore implemented sanctions, very limited sanctions, but still implemented. So we live with this concern. And as I understand, many Russian state-owned companies, that is why prefer HKC rather than SIAC. But hopefully, if they know more about this center, they may consider replacing HKC or SIAC by Asian Arbitration Center. That could be for sure. And answering to the second part of your question, yes, indeed, both HKC and SIAC they received a special permission from the Ministry of Justice to resolve disputes seated in Moscow. They got a license to administer corporate disputes. But so far, I'm not aware that any disputes seated in Moscow or in Russia, anywhere else, were administered by either of those institutions.
So I think the solution is simple. Come to AIAC to arbitrate, see to be in Malaysia. Okay.
For sure. Just I talked to the representatives of the center and proposed them some initiatives that they can support to promote the institute, not only in Russia, but in the CS region in Uzbekistan, in Kazakhstan, and other republics, former Soviet republics.
Yeah, so to answer your question on, sorry, on the impact of sanctions on arbitration seated in Malaysia, like I said, I've not personally come across a situation where sanctions have affected us. And there has been defense raised in terms of sanctions, but they have failed so far, touch wood. And in terms of enforcement as well, it's not been an issue. I've yet to come across a case where an arbitration award has not been enforced due to breach of US sanctions. But in terms of some certainty, I mean, HKIAC has come out with a policy statement in terms of what happens when a party is sanctioned. They took the easy way out, which is basically that they will not get involved, but they'll be administering the cases. Their liability is every man's risk out there. But at least there is some consideration there, or at least some policy to say this is what it should be like, actually.
Thank you, Anis. Is there any more questions from the floor? All right, just go ahead.
Hi, my question is to Dimitri. It is in relation to the legislation which gives the Commercial Court of Russia exclusive jurisdiction to try cases for sanctioned parties and the specific case that you mentioned. Do you think this is an answer to the problems that we are facing in respect of sanctions? Or do you think it might also have like an adverse effect because parties will run away from arbitration and move more towards litigation? And the second part of the question is, how do you think arbitral institutions will view this? Because often a party might start an arbitral proceedings and then go back to court saying, no, but at a certain stage, I found that, the tribunal was not fair. And as I understand from what the little that I have read, I may stand corrected, that the bar for what is fair treatment is set very low when it comes to this legislation.
Yeah, thank you for your question. The answer to the first question is yes. It was a clear answer of Russian Parliament to sanctions. And if you read the draft and explanations and comments which were given at the Parliament, you will understand that it was an answer to sanctions. So initially and at the moment, the legislation is not very clear whether the threshold should be that low, as I told you. But we now have at least 2 decisions delivered by the Supreme Court of Russia saying that the threshold is really low, and the lower courts shall follow those decisions of the Russian Supreme Court. As regards as regards what Russian parties or what what foreign arbitral tribunals and institutions shall do if a party changes its mind. I think they should proceed with that arbitration. But if the claimant is a Russian sanctioned party, I think it does make sense to proceed with the arbitration, because only if the respondent does not object to discontinuance of the proceedings, of course. And I think it's a very usual provision in many institutional rules. But I think that the Russian court in that situation will not will try the action filed by the Russian sanctioned company if it is the claimant, even though it previously had started arbitration. And we have this concept of estoppel, right? But I think it is very unlikely that the Russian court will apply that, even though the other party will object based on that concept, which we are familiar with.
Yeah, we have another question from Suim.
Good evening, Tan Suim, arbitrator. You've spoken about the difficulties in concluding the arbitration process, but you've also spoken to some awards that have been delivered. So where are you on in terms of the enforcement? Because as you said, awards are nice pieces of paper, but you still need to enforce it and convert it into cash. And I'm interested in that question relative to the awards that have been published with respect to arbitrations, but also perhaps some judgments which have been delivered by your Russian court.
So far, there are not many arbitral awards are delivered, and what we have done already, we initiated proceedings to enforce those those arbitral awards against assets in Russia, if they have them. So in order to understand whether you can collect on those awards anywhere else rather than in Russia, you first of all need to find those assets. The problem with the assets which on bank accounts nominated in US dollars or euros is that even if you find those bank accounts, you would unlikely be able to collect on them, because as Renat said, US banks are usually US bank or European banks are intermediary banks, and they won't let those money go. We certainly will not go to jurisdictions which implemented sanctions against our client. We will unlikely go to the jurisdictions that didn't implement sanctions, but express some sympathy, or that sympathy is widespread or by the citizens of those countries, because we will likely face many barriers in courts. So yeah, this is my answer. And your second part of the question was? Oh yeah, that's very difficult. As we all know, we have these mechanism of New York Convention 1958, so it's way easier to use that. As far as our state court judgment is concerned, is if you don't have a bilateral treaty, you cannot do this. There are just only, I think, two conventions and on enforcement on foreign court judgments. and just the number of the participants of contracting states to those conventions is very low, and the main players are not parties to those conventions. So I think there should be something behind the action or the sanctioned party to go to a Russian court. We definitely recommend respect arbitration agreements and proceed with initiation of arbitral proceedings. Of course, we do our best to protect the interests of our client, and if we see that there is no fair trial, we will of course signal that, and the client will decide what he should do in such circumstances.
Thank you, Dimitri. It's now 7:23. If we have another question, if we do not have, we do? All right. So that's the last question for the day.
Yeah, hi, good evening. My name is Lyra Gomez. I'd like to direct my question to Dimitri. If I understood correctly, you mentioned earlier that one of the remedies is to indicate several arbitral institutions in the arbitration clause. Is that correct?
Totally correct.
So, right. So if we do that, do we do that simultaneously or one after the other? Like, for example, if you don't get a satisfactory award or judgment in one of the arbitral institution, then you move to another. So how does that work actually in your experience? And wouldn't that constitute forum shopping?
I think, thank you for the question. First of all, I do not think having such arbitration clause amounts to forum shopping. So there are two ways of doing that. As you said, just I think you meant cascade arbitration clauses when one arbitration institution cannot move forward with the arbitration, then you have a right to apply to the other institution designated in the clause, right? So what we usually do, just we designate a special time period, and if the arbitration was not commenced or the arbitration institution is inactive, then the right arises to go to the second step and to apply to another arbitration forum. At the same time, there is another option, alternative arbitration institution selection, when a party who would like to initiate arbitration proceedings may select from the list. So it's the choice of the party where it wishes to go, and these are right is granted to both parties to the contract. Otherwise, in some jurisdictions, such arbitration clause may be found invalid. For instance, in Russia, but for instance in the United Kingdom, I think their judiciary will come to a completely different conclusion.
All right. I would like to take this moment to thank our panelists for sharing the provoking contributions, and also our audience today. Because of your questions and active participation makes this evening talk very valuable. And in closing, this is one of our AIAC evening talk series. If you do like our evening talk, please do pay attention to the AIAC website. There are more to come. I'll pass the floor back to our MC today, Ragini.
And with that, we have come to the end of our session. On behalf of the AIAC, I would like to thank the panel of the speakers for an interactive and insightful session. Now, I would like to invite Ms. Heather Yee, the Assistant Director of the AIAC, to present a token of appreciation to our esteemed speakers. Firstly, I would like to call upon Mr. Rinat. Now, I would like to call upon Mr. Dimitri, please. Now, Mr. Anis, please. Thank you. Last but not least, our very own Shuin. Thank you, Heather. And thank you once again to our panel. Yeah, could we please have the panel of speakers in front for a photography session, please? To our participants, thank you very much for joining us today. We have prepared some light refreshments just outside this room. Please do join us for the networking session. Thank you very much and have a great evening.